ahead and get started. I'll just introduce myself, and if more folks come in, then great. My understanding is that most of you are here with class or just interested, and hopefully I will give you something interesting to listen to. My name is Kimberly DeVries. I work at GRCC. I am in our general counsel's office, which means that I am in the legal office. I have a background as an attorney. I graduated from law school and was a public defender, so I did criminal defense work. And you'll hear that a little bit in this presentation. I'm going to talk a little bit about that. And then I also did civil legal aid, so like divorces and child support and family law and property law, some of that stuff. And then I got into higher ed, and now I do higher ed law. And I work with, I do Title IX work, which is our sexual assault, sexual violence response. I also do ADA, so accommodating folks with disabilities. And then I also do equal employment opportunity, so like discrimination, harassment, and stuff like that. So that is my background. I'm happy to answer any questions about that during the presentation or after, but I will go ahead and get started. Come on in. So here's what I have for a presentation for you. What I've done is kind of given you a look at writing and the law and what it looks like kind of throughout someone's maybe legal career, right? So some of these things are taken from my career and writing assignments that I have done and stuff that's personal to me. Other stuff is more hypothetical, so you can feel free to ask questions. Give me pushback, give me feedback. I welcome any of those things. So who cares? Why bother? Writing in the law and why it matters. You're going to hear a lot from me about why it matters, so please feel free to ask questions. So anybody here interested in going to law school? Anybody ever thought about law school? No? No? Nobody? Okay, never mind. Well, let's pretend that you're interested in law school. Maybe by the end, I have 45 minutes to get someone interested in going to law school. So first year curriculum in law school, after you graduate from college, if you decide, okay, I'm going to go to law school, one of the things that everybody says that you learn to do in law school is how to think like a lawyer, which most people say is an insult, but is actually not a bad thing. So what it also means is that you do a whole lot of writing, and not necessarily creative writing, not fun writing always, come on in, but specifically structured writing. Anybody familiar with this acronym, IRAC? Is something you've ever talked about, seen? So this is like the way you learn to write in law school. Issue, rule, analysis, conclusion. That's like everything you write in law school is based on that. So we're just going to go through, so you have a writing assignment, okay? So it's your second year of law school, you're in a contracts class, you are given this writing assignment, and the writing assignment is create a contract for the rental of an apartment. So what do you think you're going to include? This is thinking about writing practically, this is why it's important, because if you don't include something, it doesn't get put in the contract, and then it's not something that everybody's agreed upon. So if you're writing a contract for rental of an apartment, what needs to be in there? Give me some easy stuff. Property damage, like who's responsible? That's a good one. That's a really good one. What else? What's the obvious stuff? What unit I'm renting? When the rental agreement is for, when it starts, when it ends. What else? Security deposit. Okay. Go ahead. The duration of the agreement, is it 1 year? Is it 2 years? For sure. Security deposit, somebody said. So like who's responsible for damages, what you're paying up front, whether you're getting that back or not. What else? Pets, whether you can have a pet. Is there a security deposit for the pet? What else? How about the cost? The basic easy stuff, right? Sometimes in writing contracts, we think so much about the detailed stuff that we forget the obvious stuff, right? We forget to say when the contract's going to start, when the contract's going to end. How do you renew the contract? For those folks who just joined us, I'm kind of taking you through the writing and the life of a lawyer. So hopefully that's something that's interesting to you. That's my background. So we're starting with law school. So this is an assignment that you might see in law school, to write a contract, to write a sample contract. What else would we want to include? If it's a contract for rental of an apartment, what else? So security deposit, pets, who's responsible for damages, duration of the contract. What about what's covered in the cost? Right, because what we would see a lot is I say, okay, I paid $800 for this apartment, and I just thought that included snow removal and waste removal and electricity and power, but then my landlord says, well, gosh, that doesn't include any of those things. Those are $300 extra, right? I'm not from Michigan, so the idea of a rental agreement including snow removal is totally foreign to me. So those things that we would think about, that we would need, it would matter where it is, right? It would matter who's writing it. It would matter if somebody's familiar with this area. What all do we have to include? Anything else you can think of? What happens if somebody breaks the lease? Duration, we said that already. For those of you who have just joined us, we're talking about writing throughout the career of an attorney. So we're starting in law school, and here are the things we learned in law school. I'll take you through every step, and we'll say, what do we learn in law school? To write accurately, to write clearly, to write what you need, to write what's relevant, and largely only what's relevant. To follow that structure we talked about, that issue, rule, analysis, conclusion, how important that is. How many of you love creative writing more than this type of structured writing? Are you creative writers in here? No? Okay, I see a few. How many of you prefer like this sort of structured writing? Okay, see, some of you could go to law school. I'm trying to recruit here. One of the things that you learn in law school is how to turn off that kind of creative writing part of your brain, right? If you need to and when you need to say, you don't have to write something pretty and flowery. You need to write something that says what you mean, right? You need to write something that says who's paying the damages, when the contract starts, when it ends, what happens if it goes wrong. And then, of course, be prepared to edit. How many of you are good at this part? How many of you are good at editing your own work? I see 1, 2, okay, maybe we kind of are. I hated that part, hated it with a passion. But that is what you have to do, and you have to train yourself to do it because for a lot of us, it doesn't come naturally. Okay, so we graduated from law school. Congratulations. You passed. Your 3 years are down, and now you are a law clerk. Does anybody know what law clerks do? Come on in, guys. Anybody know what law clerks do? So a lot of judges have law clerks that write basically for them. If you think about like the Supreme Court justices, most of the decisions that they write are written largely by law clerks. People who are in the background doing all the research on other cases, writing, giving them memos, giving them documents. We're kind of going through the life of an attorney writer, so join us. So we've been to law school, and now we're a law clerk, and we're briefing cases for the judge. So if you're thinking about why your writing is important, if you're a law clerk, so in law school, it's all hypothetical, right? None of it's really real in terms of nobody's reading it. It's not going to change anybody's life, most likely. What about when you're a law clerk? Who's relying on the information that you write and research? The judge? Who else? The plaintiff, the person who's bringing the case? Who else? Defendant, the person who the case is brought against? I thought I was going one at a time there. I gave you all the answers. Think about this, future attorneys for similar cases. Here's what attorneys do when they're trying cases. They go back and they look at all these other decisions, right? Precedent is what we call it. So if you've written a decision for a judge and you've said in there that every time somebody wears a green t-shirt, it means that they're affiliated with this group or whatever, for a hypothetical, then somebody who's trying a case like that later is going to come along and find that and say, okay, this matters. So it's not just the attorneys and the parties in that case. It's the attorneys and parties in every case that has anything to do with that thereafter in that court or in that jurisdiction. So think about how important your writing is and how important it matters. Because a lot of times, I will tell you this, you know the case better than the judge knows the case. So the judge isn't necessarily going to be able to say, gosh, that's wrong, unless they just know that area of the law super well, which a lot of them do. They're going to rely on you for that. So if you're wrong, if you're making assumptions, it's going to be problematic for all of these people listed here. Okay, so most of what you do as a law clerk is research and write about it. So I was a law clerk just very briefly in law school. So you're hearing all of this from that experience and friends I have who have been law clerks for longer. So let's say that here's your assignment as a law clerk. So we saw your law school assignment. Here's your law clerk assignment. Whether the judge should grant summary judgment. Anybody know what that means? Anybody know what summary judgment is? Somebody brings a case. The other party typically files a motion for summary judgment, meaning this case shouldn't go any further, right? You either haven't stated a claim or this wasn't a violation of the law. We shouldn't even take this to a jury. This shouldn't even be heard by a judge. It should end right now, okay? So if we say that, yes, summary judgment should be granted, then essentially what we're saying is this isn't going any further, right? So this is the end of the road for this case. And if we say it shouldn't, then we're saying, okay, it should go to the next step, whether that's the judge or the jury or whatever. So this is extremely, extremely important. And I'll tell you an example. I was working, when I was in law school and I was clerking for a judge, there was a staff attorney. So law clerk reports to the staff attorney reports to the judge, right? So we're doing research for the staff attorney. So I went to meet with the staff attorney, and I had written this document saying, yes, we should grant summary judgment because there's no case here. And she looked at me and said, what about this phrase in the case? And I thought, oh, I didn't catch that. That's a lot more nuanced. That has a lot more interpretations than I thought it did. So she said, we can't grant summary judgment because this doesn't mean what we think it means. So this is super detail-oriented and super nuanced. How many of you are really good at details? Anybody? Maybe this is when it matters. This is when it so matters. Okay, so here's our issue. So an institution, an organization is hosting a farm day. This is like a PR, public relations event, a farm day. We're going to bring some kids out to the farm, and they're going to have a good time learning about farm life. So they have a tractor as part of their farm day event, and people can hang out and look at the tractor, take pictures with the tractor. So the issue that you're deciding is whether this group that hosted a farm day with a tractor, if it's negligence, if somebody gets hurt climbing on the tractor. Okay? This is a real case that I had. So the rule in your area, remember we talked about the issue, the rule, and the analysis. So the issue is whether hosting farm day with a tractor is negligence if somebody gets hurt. The rule is that negligence requires proof that there was a professional standard about tractors at farm days and that it was violated. Okay? So that's your rule. That's what you find in case law. That here's what it takes to be negligent, proof that there was a standard and it was violated. So what are you going to analyze? What are you going to focus on? You're analyzing this for the judge. Judge doesn't know anything about this case. What are you going to talk about?
Parents present.
Okay. And what does that go to in your mind?
The negligence portion.
Okay. How so? Talk to me more about that.
Where does the negligence fall? On the kid, the child, or the tractor owner, or the parents?
Okay. Okay. So like who was negligent, right? Is that where you're going?
Yeah.
What else? What else are you going to talk about? Okay. Tell me more about that. What's normal in terms of what?
Is it a standard thing for an event like this to have a tractor in which people can go touch and climb on?
Okay, I like that. What else? Go ahead.
Were there any signs like climbing on the tractor, any warning signs?
Okay.
Around there?
All right. So we said the rule is that negligence requires proof that there was a standard and that it was violated. So our analysis is going to focus on, is there a standard and was it violated, right? So we're getting at kind of some of the details of that. Were there warning signs? Were there parents involved? What do we know about what's normal for farm day events? So again, we talked about this before. If you come to the conclusion that there's not a standard, that there's no professional standard for farm day tractor displays, then what's going to happen? This case is going to go away. You're going to write a memo to the judge that says there's no professional standard, so there can't be negligence, so the case goes away. So again, important, right? Because the whole case goes away if you come to that conclusion. But if you say there is a standard and it's possible that it was violated, you're not deciding whether it was, you're saying it's possible, right? There is a standard and it could have been violated, then it moves forward. So again, judge is looking at this, we're relying on your analysis, relying on what you know, so no pressure, and you're right. Okay. So we're drafting our memo to the judge, and here's the sentence we come up with. The rules about farm safety events include rules focused on timing, equipment, and personnel necessary to run these events. So assume this is all true. So this is what we find in our jurisdiction, in our area. We find a case that says there are rules about farm events, and they include rules about timing of the events, equipment that you can have, and personnel that you have to have necessary to run the events. How do we feel about that sentence? We're editing ourselves. What do we think? Do we like it? Do we hate it? Is it helpful? It's not specific enough, okay. Anybody else? All right, let's look at another sentence. So what if we say the rules about farm safety events apply to public and private venues, including nonprofit agencies hosting charitable events? How do we feel about this sentence? Shaking your head. Why? Okay, it doesn't talk about safety aspects. Would it make a difference, like let's say this was your first sentence in your memo to the judge. Would it make a difference if I told you that the group hosting the farm day was a school, or if it was a Relay for Life, American Cancer Society, Kids Food Basket? Why?
Those institutions have their own set of standards for events.
Okay, okay.
If somebody owns a farm and has an event,
Okay.
There's a set standard for anything that follows that.
Okay. What about this? If it's a school, let's say GRCC is hosting a farm day, and you have this second sentence. The rules about farm safety apply to public and private venues, including nonprofit agencies hosting charitable events. Does that include GRCC? Potentially, right? Technically a nonprofit, if it's a charitable event, if we're raising money for American Cancer Society. Okay. What if it is a for-profit bank? What if a bank is hosting a farm safety event? Do you need this sentence? Think about relevance. Think about just giving the facts that you need. If this is a bank that's not a nonprofit, does this matter that there's rules that include nonprofit? Probably not, right? Like, okay, that might be true, but is it relevant? Probably not. What about this? The child who was injured on the tractor was wearing overalls, boots, and a plaid shirt, which are generally believed to be appropriate farm apparel. Do we feel like that's relevant? I see shaking heads. What would make that relevant? Yes. If there's a standard that's about that, right? If the standard says, well, it might matter if someone's wearing flip-flops on the farm, right? That might be inappropriate. That might make you negligent, to your point before about who's the most negligent. Then that might be relevant, right? So thinking about what matters and what you include. So this is different than creative writing, right? In the sense that what you're talking about is a little more free form, right? Whereas here, what you're talking about is dictated specifically by what's going on. Anybody have questions about that? If you were doing creative writing, it probably wouldn't be a bad thing to include all these details, right? You might want to paint a picture, this farm day, and here's this big tractor, and here's this kid with brown hair and glasses wearing overalls and a blue and green plaid shirt. But for purposes of this sort of writing, that doesn't matter. And it's kind of distracting because it's taking you away from the point, right? If it doesn't matter that he was wearing boots and a plaid shirt or that he was a boy in the first place, then you probably wouldn't include it for purposes of something like this. So what we learn is a law clerk, write in detail, but only if those details matter. If it doesn't matter that he was wearing boots and a plaid shirt, don't include it. Be prepared for editing and edit yourself. Write clearly, figure out what your audience wants to know. What is the judge trying to figure out? Is the judge trying to figure out what somebody was wearing? Is the judge trying to figure out what the standard is? Is the judge trying to figure out something else? Write in a timely way, but accurately. If you're summarizing, be accurate. How many of you tend to summarize in your writing? Yeah, I'm the same. So think about this. You find case law that says, negligence can be proven in this particular case with evidence of a widely practiced standard within the community, even if it's not formal and even if it's not in writing. So you summarize in your writing to the judge, and what you say in your summary to the judge in your memo, you say, negligence can be found in cases even without a written standard. Is that a true statement? What do you think? Can negligence be found even without a written statement? I mean, a written standard? Yes, that's true, but is it everything the judge would need to know? Would it be enough for the judge to know, even without a written standard, I could still find that there was negligence? Or would they also need to know there would need to be evidence of a widely practiced standard? Right? Your summary is not enough there because your summary only says part of it, right? Your summary is correct, but it's not the full correct view, right? Your judge couldn't say, okay, well, there's not a written standard, but that doesn't matter because there would also have to be proof that there was evidence of some widely practiced standard within the community. Does that make sense? So summarize, but you have to be accurate. And if you can't be accurate, then don't summarize, which sometimes is different than the way I think a lot of us write. We like to summarize, we like to be concise, but we also have to be accurate. Okay, so you leave your law clerk world, you become a defense attorney. And for those of you who weren't here, I was a defense attorney, so that's why you're getting this, this angle, because this was my work. So here are the things you're writing. You're writing pleadings, you're writing motions, you're responding to motions in writing. You're responding to interrogatories, which are questions for your party. You're doing responses to interrogatories and documents. You're doing proposed jury instructions as to what the jury's going to be told. You're doing opening and closing arguments. Largely, those are written. You're doing appeals, and you're responding to appeals. There are full cases that are decided on the basis of what's in writing. We tend to think of cases as always going to court, and that's largely true. A lot of cases do, but not all of them. And most of them, once they get to court, they're arguing about whatever someone put in writing before. So you're doing a motion, that's what we're arguing about. If you didn't put it in writing, often the judge isn't even going to hear it. So that's why what you write is so important and needs to be so thorough. Okay, so here's our case. You have a client. This is your first client. Congratulations. Your client is charged with possessing a handgun as a felon. So what is the state attorney going to have to prove for your client to be guilty? That's the charge. Possession of a handgun as a felon. What do they have to prove? That he had it? That he had what? A handgun specifically, however that's defined. And what else? That he's a felon. I keep going to he. That they're a felon, however that's defined in your state. That there was a handgun and that your client possessed it. So how is that defined? So let's say that in your jurisdiction, possession is defined as something being on their person, within their control, and with their knowledge. So here's a fun thing to think about. For whoever was writing this statute, so the legislator years ago when this statute was written, like to think about the importance of the difference between or and and. What if all of those were or? What if it said on the client's person or within their control or with their knowledge? It's really loose because not all of that's defined, right? We haven't defined with their knowledge, and there's no requirement that it be on their person or within their control. So think about the importance of those words. Did any of you go to the earlier presentation that Devin Swanigan did? Any of you go to that? Okay, he was within my office, and so we both talked about this. So that's why it's so important when you're writing stuff like this that you're thinking about small things like where you put commas, whether you say or and, whether you say a or the, because it matters for the interpretation, right? So this is our definition, that to possess it, your client has to have had it on their person, within their control, and it has to have been within their knowledge, okay? All right, so now we're writing a motion to dismiss, saying that state doesn't have enough evidence because they can't prove their case because they don't have those elements. So you have decided that your argument is going to be that your client, yes, is a felon. So we're stipulating that, right? There was a gun present, but that your client didn't possess it. So you're arguing one of these things, that it wasn't on their person or within their control and it wasn't with their knowledge, okay? So that's your argument. I had a lot of cases like this, so that's why I'm using this example, because I like this example. So what are you arguing? So here's one sentence. Let's edit it. Client didn't possess the handgun because it wasn't on their person or within their control and they didn't have knowledge of its presence. How do we feel about that? Is it accurate? Is it enough? What do we think? Or do we like this better? Client couldn't have possessed the handgun because it was on the passenger's person and your client didn't have knowledge of it. What do we like between those two? Or what do we not like? The first one is really just going through the elements, right? Saying it wasn't on their person or within their control and didn't have knowledge of its presence. So if you're summarizing what the elements are, that's not bad. Do we like the second one better or not as much?
Second one better.
Why?
Because it paints a better picture. Mm-hmm. Could that be replaced? The word could still kind of makes the subject, doesn't it?
Well, remember what your role is. So who are you here in this scenario? You're the defense attorney. So this is the argument you're making, right?
You want to say the client did not have possession of the handgun?
Ah, yes, I like that. Didn't? Talk to me about why you think that matters.
It's more objective. So like the word couldn't is more subjective, but I like the second bullet better than the first one.
So we like maybe the didn't from the first. So client didn't possess the handgun because it was on the passenger's person and your client didn't have knowledge of it. You like that better? Anybody else? I love that. So the nuance of the word choice, right? So couldn't is me making an argument didn't just sounds like these are just the facts. Or what about this? Client didn't possess the handgun because the passenger admitted it was on his person without the client's knowledge, and client had no control of the jacket pocket where the handgun was found. We like that better or not as much? I see iffy faces. What do we think? Does it give you, somebody had used the phrase before, I think you, a better picture of what you're going to argue? So remember what we talked about a lot of times, what you're going to argue in court is what you put in this document, right? Is what you put in this memo or motion or whatever stage you're at. So if you say client didn't possess the handgun because passenger said it was on his person without the client's knowledge, and client had no control of the jacket pocket where the handgun was found. Assuming all of those things are true, then there's your argument, right? Much clearer in terms of what you're going to say. Now here's the question. What if you want to surprise the other side and you don't want them to know what you're going to argue? Which one are you going to pick for your motion? The first one, right? Why? It says still what the elements are, and it refutes them, right? So it says these are the elements, and we didn't do these things, but it doesn't go into what your argument is going to be. You think of why you might want to do that, why you might choose not to be specific? So the other side can't start deciding how they're going to argue that? That's most of the time why you do it, right? So that the other side doesn't have a chance, so that you get in court and then you start arguing the specifics. So they don't have a chance to go ahead and decide what they're going to argue against it. Strategy, right? It's interesting. Okay, so what we learn as attorneys, be precise, be respectful. I'm just going to do a shout out, because how many of you have heard some bad joke about attorneys being rude, or some maybe story about attorneys being rude or jerks or insensitive? Yes, anybody? I see some smiles and nods. Yes, most of us lawyers have that reputation, right? Often for a reason. So this is so, so important in whatever writing you do. If you're professors, if you're attorneys, if you're police officers, whatever you are, is be respectful when you write. You don't have to say the other party is a big fat liar, right? You can say what the other party said isn't true, right? You don't have to be disrespectful or rude. Have someone else read your writing, see if they can tell the story back accurately. So what I used to do sometimes is, when I was trying juries, was go to my husband and say, okay, here's my closing argument. You tell me what you still want to know. Or here's what my client's going to say. My client's going to say they didn't have the handgun, they didn't know it was in their friend's pocket, and they were in the car, and they'd just gotten in the car 5 minutes ago. They didn't know that their friend had a gun. First, what else do you want to know, right? And often second, the question was, do you believe that, right? And what are you thinking? What are you asking yourself? So a lot of times it's helpful, any kind of writing you do, but especially when you're doing legal writing, to say, I'm going to tell you, or I'm going to read this to you, or you read it, and you tell me what other questions you have, or you tell me if it makes sense, or you tell the story back to me to see if we're interpreting it the same way. Don't use more words than you need, and back up your conclusions. Don't just make vague statements. So which one do we like better? This client can't be found guilty of possession of a firearm by a felon. There is not enough evidence, and I am stamping my feet and using an exclamation point, so you know I mean it. Or do we like, this client can't be found guilty because someone else admitted to possessing the firearm? What do we like better? One question might be, where are we using this? Go ahead. The second one, why? The elements, yep, yep. Right. Go away. That would be your argument, right? That it should go away because they can't prove the first one. What if this is, instead of a written motion, what if this is your opening statement? The first thing you say to a jury, which do you like better? A lot of people write out their opening statement so they know that they hit all the points they want to hit. What do you like better for that? Does that change? Do you still like the second sentence better? Yeah. I like that. So it kind of suggests the argument that the state can't prove it, but it still might be true, right? This is a great example of a time where it would be helpful to read that to somebody else or to say that to somebody else and say, what's your interpretation? Because that is such a legal way to say it. There's not enough evidence. That's such a legal way to say it that when I read that sentence, I didn't think that. I thought, well, that's how you would say it. You would say there's not enough evidence, right? Because that's the standard. Is there enough evidence? But you hear it as there's not enough evidence, but that doesn't mean it's not true, right? So such a good reason that you would say to someone else, and a lot of times you say to people who aren't lawyers or who aren't in your world or who don't know the case, right? To say, what does this sound like? If I say this, what do you hear? Or if I write this, what do you hear? All right, so now you have finished your work as a defense attorney, and now you're a judge. Congratulations. So what do we do as judges? And I will confess that this is the only part of the presentation I've done that I've never been. Obviously, I'm not a judge and never been a judge. I've been the other things. So as a judge, you're reviewing law clerk's drafts. Remember, when you were a law clerk, you were writing motions and writing orders. Attorney's motions, you're reviewing those, and you're writing decisions. Again, the law clerk is submitting this information to you, and you are the one whose name is on it, right? So this is why it matters as a judge. So let's say you would never actually be a judge on the case that you had litigated as a defense attorney. Obviously, that would be a conflict. But let's say that you were in this case. So you're now the judge on this possession of a handgun case, not the defense attorney anymore. So what are you ruling on the motion to dismiss? So this motion to dismiss came in front of you that said, remember, the client couldn't have possessed the handgun because it was in somebody else's pocket, right? Somebody else's jacket pocket. So what are you focusing on? In that particular case, what are you focusing on? Are you going to talk about why this person is a felon? Probably. You're nodding. Tell me more. Okay. Then it might be relevant, right, if they had some other gun charge. You might, but also remember that the argument was not focused on arguing that they weren't a felon. It was focused on arguing whether they possessed the handgun, right? They stipulated that this person was a felon. So you might also say, all parties agree this person was a felon because of this other robbery case, to use your example. It might not even be relevant. They've stipulated that they're a felon, so that's not what you're going to focus on, right? So let's see. What are you going to focus on? So this is what the judge is writing. So this is the order. This is the decision that the judge is writing. So this is no longer persuasive language, right? We're not arguing for our side anymore. This is the judge writing what they've found to be true, right? Okay, so what do we think about this? There's insufficient evidence that the defendant, meaning the person responsible, possessed the handgun. What do we think about that? Do we like it? Do we hate it? Does it tell us anything?
It's not wrong, but we need reasons why they don't have sufficient evidence.
Okay, I love the way you worded that. It's not wrong, right? We talked about before. A summary can be not wrong, but it's not detailed, right? If this were your order, this wouldn't tell anybody anything, right? They would say, okay, but we don't know why you decided that way, right? So it's not wrong, but it's not everything. Short and sweet, but it doesn't tell us why the ruling is the way it is. What about this? There's insufficient evidence the defendant possessed the handgun because there's no evidence that it was within his control or on his body and that he had knowledge of it. Better? Worse? What do we think? Yeah?
But it's not specific to this case. It just looks like it was something we could put for any charges that were submitted to it.
I like that. It's more specific for sure, but it's still maybe not specific to these facts, right? So if a party, you're the defense attorney again and you're looking at this, you might say, well, gosh, that could have been written for any case, right? So pretty standard. It talks about the elements, but it doesn't explain why the judge found the way they did. So what about this? Where whereas the sufficiency of the evidence is minimal due to the fact that the evidence of the handgun possession by the accused is not supported by the evidence, which indicates only that the handgun was found within the possession of the vehicle's passenger inside their jacket pocket and was not within the control of the client, nor did he have previous knowledge or forethought of the presence of the handgun. What do we think? Much more specific. And detailed for sure. Where the handgun was, who knew about it. Is there anything we don't like about that? It's kind of long. It's awfully wordy. Knowledge of forethought, whereas, you think that's necessary? I'll never forget my first year contracts class. Our contracts professor said, okay, let's just write a contract, right? So this is a real example. Let's just write a contract. Tell me what you would put. And one of my classmates was called on, and they said, okay, Joe, whoever it was, how would you start this contract? You know what the first thing the student said was? And we all would have said the same thing, so this is not making fun of him. Whereas. Do you have to start a contract with whereas? No. It sounds legal. It sounds pretty, right? But it doesn't mean anything. Do you even know what whereas means? I don't. It's just language that we use, right? It sounds legal. It sounds nice. It sounds flowy. Knowledge of forethought. What does that mean? It's very comma-y and lots of clauses and lots of words. It's pretty. It tells you a lot more, right? But it also tells you some things you probably don't necessarily need. So what about this? The evidence that the handgun was found on the passenger's body was not within the defendant's immediate area of control, and the lack of evidence that the defendant had knowledge of the handgun leads to a finding that there is insufficient evidence that the required elements exist. Do you like that one better or this one better? How many of you like the long, flowy sentences? I love long, flowy sentences. I love the flowery words. I think it's great because that's my background, right? Because I loved creative writing. That was my thing. So I love those words. And I tend to write that way. And you know what lawyers who reviewed my writing have largely said? X that word out. You don't need that word. You don't need that sentence. You don't need this fact. It's not relevant. It's kind of the joke that when you become an attorney, if you have attorneys higher up than you reviewing your work, they're going to redline all over the place because a lot of what you write is inevitably not important. And pretty, but not necessary. So think about that. Again, this is a legal writing thing, right? My husband's a scientist, and so he does technical writing. So we'll joke because I will write something that says, you know, the spring wind blew gently through the flowering trees. And how would he describe that? The wind blows through. It was a windy day, right? The wind blows through the trees. Much different, right? So depending on your audience, depending on how you're writing, if you're writing to a client, you might say something prettier, something flowy, right? Something nice and elegant. But if you're writing for the judge, or if you're the judge, you're going to write something a lot more concise. All right, would we change anything about this? Is there anything we think is missing? Again, this is what the judge is writing. Is there anything we would change? Maybe. Or do we like it? Yeah, right? So let's get to the point, right? So you might say this first, but then you would also want to say something like, because of this, the case is dismissed, or because of this, there's not sufficient evidence, or the motion is granted. Very good point. Like, get to the point, right? Anything else anybody would change? A lot of times what you'll hear, too, in legal world is people say, make it easy for somebody to skim it and get to the point, right? So a lot of times what you'll see is like the first sentence say, this case is dismissed. The second sentence will be this explanation, right? And the third sentence might again be, because of this, the case is dismissed. The lawyers like to skim. Most people probably like to skim, right? So that makes it sometimes easier for you to get the point quickly. All right, what we learned as a judge, write clearly. Give the details that matter, answer the essential questions, and you don't need to use, and often it's not helpful to use, fancy vocabulary. One thing, too, to think about is a lot of times when we start using whereas, or knowledge of forethought, or some of this language that we think is really pretty, what do you think we find out? People don't always know what those words mean, right? So I'll give you an example. One time when I first started as a defense attorney, I was doing a mock trial in front of jurors who weren't really jurors, right? They were my colleagues. They were friends. They were people who I knew and who knew me. And one of the things that we were doing was doing like a mock jury selection. So I was asking them questions the way that you would. And I can't even remember what the word I used was, but I used a word and someone raised their hand and said, what does that mean? So sometimes we like to think, okay, we're going to use this sophisticated language that sounds legal and sounds fancy, but what we find out is if your audience doesn't know what it means, then how does it come across? Not particularly helpful, right? Maybe leads to the impression that lawyers are know-it-alls who are not really connected to other people. Any questions, comments? I think we are at our time. But I will hang out if anybody wants to talk. For those of you who came in later, I work at the college as in compliance in the general counsel's office, so I do legal work, but I'm not the college attorney. We have a different attorney who is tasked with that role. So I do Title IX work, focused on sexual assault, sexual harassment, response to those things. I do ADA work, focused on disability accommodations. And then I also do equal employment, so focused on discrimination, harassment, and those sorts of things. I would be more than happy to talk to anybody who's interested in any of that, interested in going to law school, interested in legal work, have any questions about this. I would love to chat with you. I will summarize by saying that your writing matters, your detail matters. I will be one more voice today saying your writing matters. It's important. It reflects your work, and every career, or at least every legal career I can think of, does it. That's the joke about law school. Everybody says you go to law school to learn how to think like an attorney and to learn how to write. And then you'll learn that for the rest of your legal career. Okay, I'll hang out if anybody has any questions. Otherwise, thanks for coming. Thanks for paying attention.